The law on Section 12 and Section 14 directions on protests has dramatically changed. So whether you are a concerned global citizen urgently raising awareness of climate change or angry drivers against the congestion charge, you need to know about the law on Section 12 and Section 14. The law on Section 12 and 14 of the Public Order Act in outline is this. A senior police officer may give directions on imposing conditions on persons organising or taking part in public processions, public assemblies, one-person protests, respectively. The circumstances when a Section 12 or Section 14 direction can be imposed on protesters includes where the senior police officer reasonably believes that the public procession or public assembly may result in serious public order, serious criminal damage, or serious disruption to the life of the community, or the noise generated by a person taking part in a procession, assembly, or one-person protest may result in serious disruption to the activities of an organisation carried on in its vicinity or persons in the vicinity, or the purpose of the persons organising the protest is the intimidation of others. Moreover, the senior police officer must consider imposing conditions as necessary to prevent the above. And further, the new test of what amounts to a serious disruption to the life of the community made via regulation has significantly lowered the threshold for the police officer to impose conditions on a protest. Serious disruption to the life of the community now includes by way of a physical obstruction, which results in the prevention of or a hindrance that is more than minor to the carrying out of day-to-day activities, including in particular the making of a journey, e.g. by commuters going to work, the delivery of a time-sensitive product to consumers of that product, e.g. newspapers being delivered, or access to any essential goods or any essential service, and this is defined as in particular access to A, the supply of money, food, water, energy or fuel, B, a system of communication, C, a place of worship, D, a transport facility, E, an educational institution, or F, a service relating to health. And anyone who fails to comply with a Section 12 or Section 14 direction by a police officer can be arrested and prosecuted and faces increased punishments. The maximum sentence with the legal changes is 51 months in prison. So while the law has been changed to make it easier to issue Section 12 and Section 14 directions against climate change protesters by the police, they can also be used if you are protesting and causing a serious disruption to the life of the community, according to the police assessment, of course, if the protest is outside a media outlet or newspaper by people against media bias, or the protest is outside a bank against bank closures or interest rate hikes, or the protest is by taxi drivers who slow move their vehicles against congestion charges, or the protest is outside a fuel depot against rising fuel prices. You see, with great police powers comes great police responsibility to use those powers wisely. And with wide police discretion, whether to use the power or not, in this case Section 12 or Section 14 direction, also comes underuse, overuse, misuse and abuse of power. Environmental protest beware? Yes. But should you all be aware of these new or improved police powers against protesters, new protest offences and harsher sentences, all of which are connected to protesting in the UK today? If you or your organisation requires training on protest laws and keeping on the right side of the law, and you can find me, then call me. Feel free to comment, follow, like and share.